There's not a lot, I don't want to take up too much of your time because it's getting a bit late tonight, but I was having a chat with Barry about what sort of things are important, and the first thing that came to mind is to make sure that when you're engaging in trade or in any sort of business, you make sure that you actually read the contracts that people are supplying you. Sometimes people think they're being very smart and will put everything into a homemade little contract. They'll just write it up. They might not appreciate the fact that the sort of terms that they're asking for and they're seeking are not, as Barry said, fair and equitable. But to argue a contract is not fair and equitable costs a ton of money normally, right? And it is simply, generally speaking, not an economically sound decision to argue with a person in court, get a lawyer, fight with them over the terms of your contract. So the vast majority, and almost every person most people that I meet that do that, we have to work out a sort of compromise. You're not getting your full rights because unfortunately the only people that can ever get everything that they want that's a misnomer. The people that can have the resources to fight are people that have lots of money, right? The system of justice that we have in this country is not something which is equal to all. Everyone has equal access to the courts, but if you go to the court self-represented and you're up against, a law firm with like a group of people that are doing research and can, spit out all sorts of regulations and other case laws and precedents and all that and help sway the judge's mind against you, it's going to be a tough ask. So, first thing was, make sure you read the documents that you're getting signed. There was one little anecdotal story, I don't know if I probably shared it with this class or not, but the recent client that we had, where they're a tradesperson and they engage with a builder. I use that in the broadest possible sense of the word, because I don't even think they have a license. But at any rate, they're building some real estate, some residential property. And one of the terms in this fellow's contract, which looked like it was been copied and pasted out of different sort of agreements, was that my client had given an undertaking to provide 20 years of defect liability to any installations that they did, right? Which is about 19 years longer than they should have under law, right? Between now and 20 years time, theoretically he's on the hook to go and pick it up and fix it up. But in the event that that ever happens, then we have some responses to make, because we've given him some advice on that contract, and fortunately for my client, the contract that he signed was so poorly drafted that they actually didn't even reference their own 20-year exclusion, their 20-year product liability period, installation defect period properly. They referred to it as like Schedule G or something, and it was actually F, right? So technically there's an argument there, but I don't know what it has. So, but that's for another day. But the point being that read the contracts you've got, and if you're engaging in trade, it's good for you, this kind of leads on to the second point, to make sure that you've got specialists on your side, lawyers, accountants, business, financial planner if you need, but the lawyer and the accountant are critical. Make sure you have someone you can trust and you can talk to, and you have an understanding about what their costs are, because they might cost you a little bit of money up front, but in the short term and in the long term, I can almost guarantee you they're going to save you a huge amount of problems and costs, because it is always more expensive to fix a problem than to avoid the problem. Yeah. So with your contracts, for example, as if you're a tradesperson or whatever, and I've told this to some of my other tradie clients, when you engage with a customer, all the stuff that Barry said in relation to the importance of the relationship between clients is critical, because a lot of the time people won't sue you and people won't take legal action if they like you, right? It's just normal mentality, right? If they hate you because you're a jerk, right, and you want to you're penny pinching every cent, right, they're more inclined to also look at things in a very legalistic way towards you. If you write correspondence to them that's abrupt and harsh, right, and unprofessional, you'll probably get the reciprocal effect back, right? And they'll be harsh and abrupt with you, right? And of course, it goes without saying you should pick your customers and know when to say no to work. not all work is something that you're going to necessarily get value out of. Yeah, there's going to be stuff that you just prayed and wish that you could turn back time and say, I never wanted that job. It's cost me far more in money and my life than it actually ever warranted. But so just to get back to the point about the lawyers that you should get, when I advise my clients to speak to a lawyer first, get their own contracts in order, and understand and put into writing how they want to relate with their client, with their customer, right? Because when you have a contract that's been drafted by your lawyer, if they're competent, will tell you what you can do and what you can't do in a contract, and explain to you the mechanics of how your agreement works, so that in the event that something bad happens, right, you know, and you don't have the anxiety of worrying, well, what do I need to do next? Who do I need to call now, right? Because you've drafted the contract and you've been involved intimately in the process of understanding how you want to relate to your customer. One of the Sparkies we're dealing with right now, right? Going back to a subject, if some of the guys who've done Kurt's class with us, he was mentioning about the security of payments legislation, right? If you're not familiar with it, it's an incredibly powerful tool in law, right? Which was designed to avoid and assist tradespeople with their cash flow. So it prohibits contracts between builders and tradespersons who insist on saying, well, we'll pay you when we get paid. Pay when paid contracts are illegal in this state, and in most states, I think, right? But a lot of people don't know that, and they think, well, it's only fair.
Do you come across many of them, John?
Sorry?
Do you come across many of them?
Yeah, I do, right? People do it just because they want the work, right? Very rarely will a builder be silly enough to put in writing that that's a term of your engagement, right? Unfortunately, I've heard stories even with very large builders, like the big commercial, multinational sort of builders, that if you use the law in a way which protects yourself, like security of payments and insisting that you're paid when, within that 15-day, or have the payment, the payment summary sent back to you and all that sort of stuff, they will actually blackball you and not trade with you, because they don't want a person that's going to enforce their rights. There was, actually, I don't know the details of the story, so I won't actually mention it, but back to my point in relation to your contracts. When you understand that, look, when I issue an invoice to my customer, in my head it's clear. They've got 15 days to respond to me, either pay my bill or tell me when they're going to pay my bill. And once I receive that, if I don't agree with it, this is the process that I follow. And your accounts people or your bookkeeper, whoever it is that's helping you out in your business, needs to also be on top of this. So you can focus on getting more work and doing it, and they can focus, or you can, at least there is some sort of meeting of minds in your own business as to what the process is when you don't get paid. Because not getting paid, or getting paid too slowly, is pretty much the same thing, right? So things like security payments rules and making sure that you can have legally enforceable rights for collecting your money is really important. And having that advice off the bat when you're starting your business is critical, right? Which then goes to the other and the last point that I want to raise, which is insurances. To make sure that you're structured in such a way, your business, when you're engaging, that you're doing the best you can to protect yourself from liability, right? Because mistakes will happen, stuff-ups will happen, and invariably people will occasionally point the finger at you, or you might get roped into it as an intermediary between you and someone else. We had one matter which we had a settlement conference on last week, where they were a large South Australian residential builder. My clients were a country client, and long story short, the builder laid the wrong foundations. I don't know if I mentioned this story or not, but the footings that were designed were too weak to support the house, because the bore logs that the people took when the footing design was earlier done, was actually from a different site. So the guy that actually did the bore log stuffed up, gave it to the engineer at the time who did incorrect calculations because he was going on incorrect bore logs, and then my client sat on that for 4 years and didn't do anything about it because he wasn't going to build. And then he goes to the current builder who used those old and incorrect bore logs that no one knew were incorrect, did footing designs without checking and verifying it themselves, built a full-on house, spent $500,000, only to find out 4 years later that the house is cracking in two because the soil was too reactive. Who do you sue? The guy that took the bore logs, the engineer that did the initial spec work, the engineer that did the contract with the builder that you've got that's actually built the home, the engineer that the builder used to design the home? Or do you sue the customer who owns the home because they're the ones that provided the report to the company? So it's like a huge mess. Who do you take action with?
And who are you representing?
We're representing the owner of the house.
Right.
All right. I'm happy to say, well, actually I shouldn't speak too soon. We have had tentative resolutions to the matter where effectively the only way to clean this up, and the important thing, and the reason I raise it as an example is, everyone along the chain has insurance for professional liability, for professional indemnity, right? Which means that, or if they didn't do the job quite properly or there was some mistake for which they're responsible for, right? Because it was arguably both the first engineer's fault and the second engineer's fault that the footings were incorrect. They should have checked.
I think the blame lays in quite a few different spots. And
The blame, yeah, and that's the argument that the other side's lawyers are making. They're pushing the point that, well, your client's 30 to 40% to blame. I'm like, how is my client 30 to 40% to blame? They acted like couriers. They're not builders. They were like postmen. They were given a report and they handed it to someone else. Plus, they paid the new company to do bore logs and engineering separately, right? So I'm like, how is my client responsible? Notwithstanding my rebuttal at that point, they have a valid legal point. My client may very well be held to be responsible to some extent, right? So that's a factor we've got to consider. But if any one of those people along the chain didn't have lawyers or didn't have insurance, getting involved in this sort of litigation would have been extremely expensive for them. Because just getting a lawyer to go through that and digest the information would have cost them off the bat before the first meeting $5,000. Just to sit down and have a read of it, right? And then the meeting that we had last week, where we tried to settle the matter, that took 3 hours. We reached a resolution, but that meeting, adding up the numbers about how much it actually cost the people, like all the parties involved, that would have been close to $10,000, that 3-hour meeting. Because you had 2 sets of lawyers with like 5 sets of different litigants, all like in a Zoom meeting together, having what's called a pre-action meeting, right? Which is the meeting you have before you start the court case to figure out who you're gonna sue, right? And whether or not you're actually gonna sue or whether you can sort it out. So, critically important to have insurance, and I can't stress enough, never ever buy insurance off the internet, right? They are designed to sell you cheap insurance. Cheap insurance is like flushing your money down the toilet. Because insurance, the way insurance works is, it's a contract. It's a private contract, right, between you and an insurance company, where you tell an insurance company, hey, I'll give you $1,000 a year, and in exchange for my money, according to the terms of this insurance contract, you cover me for any mistakes that I do, as long as those, and they'll say, yes, we will, as long as those mistakes are this, and this, and these things don't, and these other things don't happen, right? There is no general law that says an insurer has to cover you if you fucked up. Their policies of insurance are private contracts, and private contracts can be negotiated. So before you start working, you have a right to actually negotiate and make a customized insurance policy specific to your type of work, which you cannot do if you buy an online product. But the only guys that can really do that, I don't know if they're the only guys, but The people you would use to do that would be brokers. So you should find a good quality, reliable insurance broker, right? Because their job is to negotiate the insurance contract for you. If you're big enough, they'll actually go all the way up to London, which is like where the major insurance risk is distributed through all the insurance companies around the world, right? Like, I don't know, who would like, if it's someone like, who are like some of the big national builders that, I don't know. Who? Land lease, whatever,
Yeah,
right?
huge.
They would have massive risk portfolios. So you're not going to find Allianz going to cover them. They certainly wouldn't have gone online and picked up a policy. The scope of your work, I do $10 billion worth of work a year. So their policies won't cover you. Those kind of people go to, there's a place in London called Lloyd's,
Yeah.
right? And Lloyd's is a place where everyone is like in suits and smoking and all that sort of stuff. I don't know what it really looks like, but that's where they haggle and agree on insurance risk distribution.
Yeah.
And that's where they sell insurances to each other and say, I'll buy your policy and your income stream, and I'll sell you mine, and we'll underwrite one another. And if something bad happens to you, well then, because you gave me a share of your returns that you're getting every year, I will promise to cover you for this amount of liability. Which is fine when nothing wrong happens, but then when 9/11 occurs, right, or when the financial crisis hits, right, the GFC in 2008, all bets are off. Well, all the bets are not actually off, all the bets have to be paid for, right, and that's where you have massive changes in net wealth. At any rate, so I'll wrap it up. Read your contracts, get a lawyer, and make sure you have insurance. And an accountant as well is very important, right? Those are, I think, really critical things for you to have if you're starting off in business. Don't worry about spending the first $2,000 or $3,000 to get the right sort of advice. Make sure you're comfortable with, I can only speak of lawyers, I can't speak of accountants. I've made my fair share of hiring the wrong sort of accountants, which are useless, but you sometimes get a feel with working with people, right? And you know if a person you're talking to, if it's a lawyer or whatever, you're comfortable talking with them or you're not, and you'll generally tell by the first bill whether or not they're the kind of people you want to work with, right? If you get bill shock after your first account, then you might want to look for another lawyer, right? Or if, here's a little tip as well, free advice. When your lawyer has other people in the room with you, like other lawyers or paralegals or whatever, you are being billed for their time, right? They are not just there to kind of populate the room. Every person that's there is most likely going to be charging you. So when you get your bill and say, hang on, I only had one meeting, how's it $1,000? Says, well, I was there, my senior associate was there, and the paralegal was there taking notes. I'm like, what the fuck were they doing? They were literally doing nothing. They were just sitting there, they were scribbling some notes. You could have taken your own notes. You are completely within your rights to tell your solicitor, please ask everyone else to leave, it's just you and me talking. I do not want to spend my money having them there to write your notes. You write your own notes, and you can explain it to them later, but not on my dime, right? So that's one thing, that's a free nugget of advice to bear in mind. But do get a lawyer and get a reputable one who knows the area that you want to work and they can help you out. That wasn't a plug for me, by the way. Just call me if you ever need me to say.